Department. Now it's a great pleasure to introduce, also from Trinity College, Dr. Eoin O'Dell.
Good morning. Now that we're past Halloween, I think I should say Merry Christmas. I'm thrilled, delighted, honoured to be here. I have been a relatively avid watcher online, so it's very nice to move from being a lurker to being a participant. I'm picking up where Neville left off. In fact, everything I know about blasphemy I've learned from Neville, so effectively, minus the bad jokes, which are all mine, everything I'm about to say, Neville could have said, and in another audience probably would have said. But the convention decided they wanted two different voices, at least one bad joker, so here I am. I know Halloween was the other night, but I didn't get dressed up. Now, we're here because Article 40, Section 6, Subsection 1, Paragraph 1, the very last sentence of that article, as Neville has said, says that the publication or utterance of blasphemous, seditious, or indecent matter is an offence which shall be punishable in accordance with law. Now, Neville has given us the history of where that came from, and he told us about the Corway case. During the divorce referendum, this was one of the anti-divorce campaigners' main slogans, "Hello divorce, bye-bye daddy," and the Corway prosecution excuse me, related to a cartoon in the Sunday Independent, "Hello progress, bye-bye father." Full disclosure, I have this image because Neville photocopied it from the paper at the time and then gave it to me. So again, it's all thanks to Neville. And we ended up, because the Supreme Court in Corway ducked its responsibilities, we ended up at Section 36 of the 2009 Act. And this is a summary of the section. All of the articles and sections that I'm talking about are in the appendices to my submission. A person who publishes or utters blasphemous matter, that is the constitutional phrase, repeated in the text of the section, shall be guilty of an offence. Then there is a long definition of blasphemous matter, which is quite narrow. A defence which is effectively a freedom of expression defence, and it's quite wide. And exclusion from the definition of religion of paying cults, effectively. So, as Neville has said, it's quite a narrow, quite tightly drafted section. Now, bear with me for a minute. I'm going to bore you in exactly the same way as I bore my first years. Neville's going to go to sleep at this point. I'll wake you up in a few minutes. I'm going to talk about the 4 R's. Now, we're not talking about reading, writing, arithmetic. We're not talking about reduce, reuse, recycle. We're talking about 4 different R's. Let's assume that somebody wants to challenge Section 36 on the basis of the Irish Constitutional Protection of Freedom of Expression or Article 10 of the European Convention. And the reason for this thought experiment is because the constitutional contours of these free speech clauses will determine the ambit within which statutory reform could happen, and an analysis of those constitutional contours will determine the extent to which constitutional reform might be proposed by the Convention. So let's assume we have a restriction, such as Section 36. That restriction is a restriction on a right, in this case freedom of expression, in Article 40, Section 6 of the Constitution or Article 10 of the Convention. Now, it's not enough that the state introduces a restriction. They've got to have a good reason for it. And it's not enough that the state has a good reason for it. The reason has to fit the restriction. There's got to be a standard of review, a balance. The state can't say we've got a justification and then go too far. So the 4 R's of constitutional review, whenever there is a restriction, a statute that you're challenging, on a right in a constitution or a convention, the state has to have a good reason for the restriction that justifies the restriction in question, and that's the review stage of the inquiry. Now, this is the full text of Article 40, Section 6. It's in your materials as well. I'm not going to play PowerPoint karaoke. I'm not going to read the whole thing. It's a pretty hideous section. Rights should not really be protected by long, complicated, tedious sections. The Irish Constitutional Freedom of Expression right does. What is the right? If we have our restriction, the Section 36, what is the right? Well, the right in this article is the right of citizens to express freely their convictions and opinions. which isn't, note, the right of citizens to freedom of expression. It's only convictions and opinions. Now, the Supreme Court has broadened it, so that language is not as narrow as it might at first blush appear. But scarily, it is made subject to public order and morality. Not only does the last line create a constitutional crime, in fact, 3 constitutional crimes, but the first line, instead of saying we have a right, says, no, you don't. It makes the rights subject to public order and morality. And there are lots of reasons for restrictions apart from public order and morality, which is stated twice. There's the common good, the authority of the state, as well as blasphemy, sedition, and indecency. Okay, what is the standard of review? It's not enough that the state says, yes, we can justify our legislation on the basis of public order. What is the standard of review? Well, the text doesn't give us one. It makes it very difficult for the court to determine the constitutional validity of any speech restriction. However, the courts have said that there must be a proportionality, a balance between the end that the state is seeking to achieve and the restriction that it is implementing to achieve that end. So even though there isn't a constitutional standard of review, the courts have generated one. Now, so we can see that if Section 36 is a restriction on the right to freedom of expression, there are various justifications or reasons, public order, morality, common good, and the religious rights of others, that could justify the restriction, provided the restrictions are proportionate. One of our leading cases on the definition of proportionality is a bit like what the High Court said in the Corway case, which is that the main justification at common law for a blasphemy offence is the risk of public disorder. And in the Jerry Springer case, an attempt to take a private prosecution, much like Corway, to prosecute Jerry Springer the opera. Now, I would have prosecuted it because it was a very bad opera. That's 3 hours of my life I'm never getting back. But I'm not really sure that we can prosecute something just because it's bad television. Otherwise, you know, a great deal of what's currently on television would be a criminal offence, not just an offence against my time and your taste. Anyway, so the High Court in the UK, in exactly the same way as the High Court in Ireland in the Corway case, said the common law offence required the risk of public disorder. There weren't riots on the streets after Jerry Springer the opera was broadcast on the BBC, merely that there were 300 angry telephone calls to the BBC switchboard. That didn't amount to public disorder, no justification for a public prosecution. So what the courts have said when they have looked at it is that the main justification for blasphemy at common law under statute is that there is a risk of public disorder. Article 10 of the European Convention, the other clause that I said we would measure blasphemy rules against. Now, this is much cleaner. It seems as long. I'm still not going to play PowerPoint karaoke, but it's actually a much easier clause to parse. It starts off with a straightforward statement of the right to freedom of expression. Everyone has the right to freedom of expression. And then it gives some detail. It includes freedom to hold opinions and to receive and impart information and ideas. So now we have a clean statement of the right, and it starts with the clean statement of the right. It then goes on to set out a closed list of reasons on the basis of which legislation might be justified if it infringes the right. Again, I'm not going to read them all, but I am going to point to the ones that are relevant to our discussion today, which is that the prevention of disorder, the protection of morals, and the protection of the rights of others. These are the 3 main sections in Article 10.2 of the European Convention that have been relied upon in the cases that Neville referred to earlier, and in 3 subsequent cases as well. And on the face of the text, there is a standard of review. It's not enough that the legislation you can point to the risk of public disorder, the reason for the protection of public morality, or for the protection of the religious sensitivities and rights of others. It must be necessary It must be necessary for that end. It's not enough that it's a good idea. It's not enough that it's desirable. It must be necessary if it is to be a justifiable infringement. And the court has said that it will be a necessary infringement if it is a proportionate infringement. So the courts are all tending to the same standard of review. And again, we can run through Section 36 as against Article 10 and see the same various grounds to justify, to seek to justify as reasons for the restriction, and then the same standard of review. So, those are the constraints. What's before you today? Well, before you today is a series of questions at the constitutional level and at the statutory level, because this is all about the interplay between the last section of the last sentence of Article 40, Section 6, subsection 1, paragraph 1, and Section 36 of the Defamation Act 2009. So the constitutional questions before you today are these. Do you leave this long clause as it is? The courts have been muddling through, they've been beginning to make it work as a constitutional free speech clause. Yeah, there are lots of things we wouldn't do if we were starting again. We wouldn't put a restriction at the start. We wouldn't necessarily put a constitutional crime at the end. We would word our standard review better. But basically, the courts are muddling through. So, you know, it's working. It's like a 1970s car that you keep repairing, or a 1930s car even that you keep repairing. It's still going on the road. Why trash it? So the first question is, or the first option is do nothing. Leave it alone. It's fine. The second option, is to delete the word blasphemous. Interpret your role literally as looking at blasphemy and just delete the word blasphemous from the last clause of the Constitution. That, of course, the last clause of the Constitutional Protection of Freedom of Expression. That, of course, leaves the other offences intact, so you might consider going further and removing the constitutional crime completely. I entirely agree with Neville that it is odd, it is bizarre in fact, that a constitution which should be a statement of general principle about the nature of the relationship between the citizen and the state and the ordering of the state should contain on its face a constitutional crime. So you could decide to go further. You could decide to go further again and delete the whole thing and replace it. Delete it on the grounds that it's a messy and ugly. It's not very workable. The courts might be muddling through, but it is muddling through. The language is archaic and outdated. And I, in my modesty, in the submission, have suggested an alternative wording modelled on Article 10, but taking some of the words from Article 40, Section 6, that the courts have, in fact, provided clear interpretations for. And as we saw, it was much easier to make Article 10 conform with the standard pattern of analysis. In the same way, my modest proposal of a new Article 40, Section 6, subsection 3, modelled on Section 10, also conforms to the standard pattern of analysis. So those are your four constitutional questions. Leave it as it is, remove blasphemy, remove the three crimes, rip it up and start again. And of course, if you're ripping it up and start again, you take my modest proposal as your basis for doing so. The statutory questions. This, by the way, is the first blasphemy act in the United States. It was the colony of Massachusetts in the 1690s. I couldn't find an earlier text online. This is, again, the structure of Section 36 of the 2009 Act. And various questions again arise. The first one is, well, do nothing. It's perfectly fine, leave it as it is. The second would be to amend it in some way. If you take Neville's view that it's narrow and unworkable and you think that it ought to be made broader and more workable, you could amend it by taking things out. On the other hand, if you felt that the absence of an express reference to public disorder raised questions because of the High Court judgment in Corway, the High Court judgment in the Jerry Springer case in the UK, and certain observations in the European Court of Human Rights, then you could amend it to add in an express reference to the likelihood of public disorder before the offence is triggered. You could get rid of it completely. And if you got rid of it completely, then you could look to see what other people have done. And in the submission, I have an extract from a Council of Europe document, which refers to, I'm not going to make you read that tiny little print on that screen, it's just to show you that it's in the submission, in Appendix 2, which lists 45 countries, all of which have done something in this sphere. Not necessarily, in fact, not usually at the constitutional level, usually at the statutory level. Sometimes they call it blasphemy, sometimes they call it religious hatred, sometimes they have other names for it, but they have all done something. So, if we get rid of the blasphemy provisions out of the Defamation Act, what could we do instead? Well, the Prohibition of Incitement to Hatred Act already prevents incitement to hatred on the grounds of religion. Now, it doesn't go any further, that's all it says, but at least it's there and at least it's a starting point if you want to build on a replacement. The Legal Advisory Group on Defamation, which drafted the heads of the bill that became the Defamation Act 2009, didn't suggest the blasphemy offence. They suggested an entirely different kind of offence of gravely harmful statements. That's a possibility. Or in the UK, there is quite an extensive set of provisions relating not just to racial but also to religious hatred governing these provisions. And if you wanted to, you could supplement the single word religion in the Incitement to Hatred Act with the extensive provisions in the UK defining religion and defining incitement and defining hatred in these circumstances. So there's a whole range of statutory options if you decide to get rid of Section 36. Lots of other countries have done something similar. Because it's in English, I have given you the text of the English Act if you are in need of something to cure tonight's insomnia. Thank you very much indeed.